Hi, this video is a part of the Technology in Education course that we're running for the Teacher Ed team at APU, and it's a recap of what we talked about in session 3, part of which was an introduction to copyright law. So this video probably won't be very useful by itself, but if you attended that session, or if you watch this video now and then go and read all the supplemental materials that we've put on the course WordPress site, then this might probably be of use. So by itself, it may not be very useful, but it's intended as a recap for people who attended that session and as part of the set of materials for people who couldn't attend that session. All right, then. So let's move on to what we talked about. Because we had to talk about copyright law, which is a species of intellectual property law in general, we said that it would be important to try and understand the meaning of the term intellectual property first. So that's what we did. We started off by trying to understand the term intellectual property, and as you can see in this chart, went all the way through to the internet and how it's affecting copyright law now. Now that particular session was about an hour long, but we're going to try and keep this short, so it'll probably be quite quick. But if you have any questions or doubts, just post them on the course website and we'll respond there, or we could meet in person and talk through any doubts that you might have. Okay then, so intellectual property, let's just break this up into two parts in order to try and understand it. Let's take property first. Now, this seems like a fairly familiar notion. All of us have heard about property. Some of us may own property. Some of us may own a lot of property. Now, what does it mean really when we say that I own property? What are these notions of ownership? What does ownership mean under the law? Well, very simply put, when it comes to tangible, immovable property, such as land or a building, for example, when the law says that you own something, basically it means that you have exclusivity over that property and over the use of that property. So in the case of a house, what might that mean? Suppose I own a house somewhere. Now that means that I can choose to do whatever I decide with it. I can live there. I can give it away to someone. I can sell it to someone. I can give it out on a license or a lease, rent it out to somebody. I might allow somebody to live there temporarily. I might decide to demolish the house and build a new one. All that is completely up to me. Now, let's take the other part of the definition, intellectual. Now, very simply put, the term intellectual here refers to anything that is a product of the human mind, anything that is created by the human mind. So any property that is created or that is a result of human creativity is called intellectual property. Typically, this is intangible, which means that you can't really touch or feel it, but it is property under the law. So what does it mean to own intellectual property? What are the notions of ownership over an idea? It's a little similar to how the law treats immovable property. Essentially, what the law says is that you have a monopoly over the use of that idea or over that idea in different ways for a limited period of time. Now, what could that monopoly be used for? Depending on what sort of idea it is, you might decide to use that monopoly in many different ways. So for example, suppose you've written a book. Now in the case of a book, you have the right, the exclusive right to make copies of that book, to allow derivative works to be made of that book, and also of course to license your rights in that book to somebody or to assign them completely to somebody else. In that sense, the idea of what can be done with property when you own it in the case of both intellectual property as well as real property are fairly similar under the law. Similar to the extent that you are essentially given bundles of rights over property, whether it is immovable or it is intangible intellectual property. So a bundle of right means, just like we said, you could do so many things with property that you own. All those different things together constitute the bundle of rights that translates into ownership under the law. And you can decide to exploit those rights, or use those rights, or enjoy those rights in any manner that you deem fit. There are, of course, some differences when it comes to intellectual property, a number of differences when it comes to intellectual property as opposed to immovable property like land or a building. And so these special features are all encapsulated under this body of law called intellectual property law. Although this session will focus on an introduction to copyright, it would be a good idea to try and understand some of the major streams of intellectual property law, so we have a better idea really how copyright is unique. So the three sorts of intellectual property that people typically talk about when they talk about intellectual property law are copyrights, of course, then patents and trademarks. Now, these forms of intellectual property, or rather the manifestation of the law relating to these three forms of intellectual property, are so ubiquitous that these have pretty much come into common usage, and we use them in common parlance nowadays. You wouldn't be surprised to hear somebody say that they have copyright over something, or that they have a patent, or that they own a trademark. But everyday notions of what each of these are may be a little wrong. So it would be useful to try and understand them. Okay, so let's come to copyright last because we're going to talk about it in detail. Let's start with patents. Now, what are patents granted for? Patents are essentially granted for what we typically call inventions. All right, if I create a new thing, if I invent some sort of new machine, then I will be given a patent over it, which means that I alone will have the right to make more machines like that, to sell them, distribute them, and so on, and to give these rights away to other people on such terms as I see fit, provided that after the term of the patent is over, anybody has the right to then start making more machines like that. So I have a monopoly limited in a period of time to exploit my invention. After that period of time expires, anybody else can exploit that idea or that invention. So this is an example of the typical justification for why intellectual property law exists and why it grants monopolies to creators of ideas. The logic is that if I protect you for some time, you will be able to exploit your idea or invention. Once you've had that benefit, you must give society the benefit of your idea or invention, and anybody else should be allowed to freely exploit that idea or invention. So it's some sort of encouragement that's given to creators or inventors. Trademarks are different from patents. Trademarks are easily understood, or most easily understood, as the identifiers of the manufacturer or producer of goods, and now of course services as well, and a number of other things. So what that means really is that trademarks are a measure that have been introduced under the law so that customers or consumers may be able to identify who made those particular goods or who is providing those particular services that they are trying to decide whether they want or not. Equally, they are now very, very big in terms of being brands. So a brand has very, very high value. It actually has a lot of commercial value and importance nowadays, and it's important to try and protect your brand. How do you protect your brand, your reputation? You protect it as a trademark. So in that sense, different from patents. Finally, copyrights, which are different from both patents as well as trademarks. Very, very literal sort of understanding what a copyright would be, again, to just break this term up, If you have some sort of creative idea, some sort of literary, musical, artistic idea or creation, you have the exclusive right to make copies of it. Essentially, therefore, nobody else can enjoy that creative work or that idea or creation until such time as you have copyright over that work. Now, what sorts of works are protected under copyright law? Essentially, any sort of creative idea. What this translates into, and we can look at particular sections of law in our supplemental reading, are literary, artistic, dramatical, and musical works. These are the sorts of works that are protected under copyright law in India. Then there's a category of works called derivative works. Derivative works essentially are derived from this first set of works that we talked about, literary, artistic, dramatic, and musical works. These may include things like cinematographic films and musical recordings. So films and songs and so on are considered derivative works because really they are combinations of these other forms of work. So for example, a musical recording or a song would be a combination of lyrics, which are literary works, the music itself, the score, which would be a musical work. In each of these, there is somebody who is assumed to have copyright at the time of creation of the work. These are important terms, so we'll go over them. For literary, artistic, dramatic, and musical works, this is someone called the author. And in the case of derivative works, this is somebody called the producer. Essentially, the person who's brought all these elements together and caused them to be combined. How do you have copyright in a work? Is there some sort of special process that you have to follow or some form that you have to fill out and submit? No. You could register a work under copyright law. It helps to establish proof and so on and so forth, but it's not a necessary condition. Essentially, the instant you create any of these forms of work, which is new, which hasn't existed before, you won't copyright on that. So as an example, as I'm going through this video, as I'm going through this explanation, I have got copyright over the blank or the empty chart that I started out with. Empty in the sense of no annotation, so that initial chart, the clean one. Now, even in this form with all these annotations, I have copyright over what I'm doing. I have copyright over the video that is being published now, and I haven't had to do anything to obtain that copyright. I haven't had to register it or file it anywhere. One difference, since I work for Azim Premji Foundation and since I signed a contract with them which said that any work that I make during the course of my employment or engagement would belong to APF. So this video, because I'm making it during the course of my work at the foundation, the copyright in it now belongs to the foundation. As an author, I could decide to assign or license away any of the various rights that I get under copyright law over my work, such as the right to make copies or the right to make derivative works, so on and so forth. I, aside from these, also have something called moral rights. So authors have something called moral rights under copyright law as well. What are these moral rights? These moral rights include things such as, for example, the right to be identified as the author of the work, the right to integrity, so you can prevent somebody else from making too many drastic changes that might change the fundamental nature of your work, and so on. These two can be assigned under the law. All right, so that's a quick overview of the sorts of works that copyright protects and the sorts of rights really that you get under copyright law. Now there's many more types of rights as well. So there's something called performers rights and broadcasting rights and so on, and we can go into those in detail later, but we don't really need to know too much about them right now. Okay, so literary, artistic, dramatic, and musical works, various sorts of rights. Essentially, you could consider these to include the right to make copies, the right to make different versions, derivative work, so on and so forth. So I think up a story, I have the right to publish and distribute copies of that story in the form of books, to allow somebody to make a film out of that, to allow somebody to make a video game out of that, to make merchandise, toys, collectibles, any sort of thing really that I can think up which might help me exploit the commercial value of that idea. All right. So those are the sort of rights that you get. We said that under intellectual property law, you get a monopoly limited in time. So what time period are we talking about? How long does this monopoly extend? In the case of patents, 20 years. In the case of trademarks, 12 years, but this is renewable, which means that if you have a trademark and you're using it continuously and you can show that, you can ask for that trademark registration to be renewed every dozen years or so. Under copyright law, the term of copyright under Indian law for most works is the lifetime of the author plus 60 years. So that's a pretty long duration. So lifetime of the author plus 60 years. This varies across the world. So in some places like the US, for example, it's the life of the author plus 95 years now. The minimum that you would find in most places is the life of the author plus 50 years. Now, this is something that people have agreed to as a minimum under a number of treaties and conventions that we've signed, which include the Berne Convention and so on. However, what we need to remember for our purposes is that copyright term in India is the lifetime of the author plus 60 years. So I think up a story right now, I alone have the right to print it and publish it as books for my entire lifetime and my heirs after my death for 60 years after. So that's pretty tight. I mean, in terms of the sorts of protection that you might get and the duration of the protection that you get seem fairly extensive, and they are. They are extensive to the extent that, for example, under Indian law, there are criminal penalties for infringement of copyright or violation of copyright law. However, there are no criminal penalties. There are only civil remedies in the case of infringement of trademark or of a patent. There are, however, certain exceptions that are provided under the law. What are these exceptions? These are exceptions to the monopoly of the owners of copyright. Now, these are found in a place called Section 52 of the Copyright Act in India, and these list certain sorts of uses or certain sorts of situations where, although somebody may have copyright in a work or copyright subsists in that work, you may nonetheless be allowed to exploit that work or to make copies of that work or use it for different purposes. So some of these are called fair dealings, and these are the sort of exceptions that may be most relevant for our work. So you have a fair dealing exception, for example, for the use of any material, even though copyright may subsist in it, for the use of instruction in a classroom. There's a teacher, there's a pupil, you want to show a film, you can, even though the film may still have copyright subsisting in it. However, you decide to show that film at home and sell tickets to people for 5 rupees each. That's not allowed. That's not fair dealing because it's not for instructional use or genuine educational use. Similarly, it can be used for the purposes of research. So education or teaching would be one use, research or commentary or analysis might be other uses. There are no clear guidelines that tell you what the boundaries of fair dealing are. So it would be great, for example, if the authorities published a set of guidelines which said this is what fair dealing means, this is what you can and can't do. However, these don't exist in India. So it would be a good idea to be extremely cautious when you're using other works for any sort of purposes, and check whether that use falls under the descriptions that are listed under section 52 of the Copyright Act. So suppose you're publishing an article and you want to quote extensively from a previously published article. Can you pick up 3 paragraphs from that preceding article, from that older article, and reproduce them in the article that you're writing and want to publish? There's no clear answer. Depends on how big those paragraphs are. Depends on how big they are in terms of how big the other article is overall, and so on. So generally, it's a good idea to try and use as little as possible to cite, to make sure that you identified the original source, and please make sure that you also consider for what use you are reproducing other copyrighted work. So if, for example, you're publishing something for instructional purposes, it may be permissible to take some sections from other works. If, however, you're publishing for commercial gain and not for instructional use, then you may not be allowed to extract from other materials. Suppose you're putting together a set of reading materials for students who may sign up for a particular program that you're designing. Can you extract an entire article and reproduce it as part of these reading materials? Very simply, the answer is no. Can you reference it? Can you quote from it? Yes. How much can you quote from it? Depends from case to case, and there are no clear guidelines on that. So one should be as careful as possible. Alright, so that's really what copyright law looks like. But given that this is something which relates to works that are created all the time, continuously, and in constantly changing, rapidly evolving environments, there are a number of debates around the nature of copyright law today and whether it works. Why do these debates arise? Well, the simplest explanation is, since the time that these sort of laws were first thought of, so we're talking about around 1710, which is when the first copyright statute or the first copyright act as we understand it today came about in the world, in the UK, to now, the nature of the means of reproducing works and recreating works and making new works has changed dramatically. So we're talking about a change as big as going from printing presses, which were the state-of-the-art technology in 1710, to computers and the internet, which is what pretty much everyone's got at home now in 2012. It's much easier to make copies of works. It's much easier to send them across borders. It's that much more difficult, therefore, to try and understand how ideas of copyright law, which are as old as this, can be applied to the current context. So there are some people who feel that it makes no sense anymore and it needs a thorough recasting. Some people even argue that we don't need copyright law at all anymore. There are varying shades of this debate, and there's a number of things that you could read up about here. This, or a set of collections of, or a set of essays which include such debates, are also part of the reading materials that everyone has access to. So I would suggest very strongly that you go through some of them at least. But there have been responses to how to work with copyright law as it exists today. Even though some people feel that it's in need of change, they've come up with ways of working around it. So there are progressive licensing ideas. The one that you may have encountered the most often or heard of or seen are what are called Creative Commons licenses. So a link to the Creative Commons Choose Your License page is also available as part of your materials on the course WordPress site. It would be a good area to click through on that and look at how these various licenses are put together. But essentially, Creative Commons licenses recognize that a lot of work nowadays is the result of a number of influences of other works that one has already seen. Creative Commons licenses encourage sharing, encourage distribution and the dissemination of new ideas, and new works. At the same time, the people who came up with these licenses understood that authors or creators of works might need some form of protection, and they leave it to the author to decide how they want to license their works. So, for example, under a Creative Commons license, one may say that, all right, I allow anybody to make copies of my work and use it for whatever purpose they like, as long as they identify me as the author. So that's something called attribution. Otherwise, you may say, I want attribution. Also, anybody can use my work and make copies of it and create derivative forms in any manner they like, as long as it is not for commercial purposes. So you could have an attribution and non-commercial license. You could also say that anybody else can pass on this work after recreating it and so on, as long as they use it for the same purposes or under the same terms that I've licensed it, which is a share-alike license. So there's a lot of flexibility really that you have, and you could design your own Creative Commons license depending on how you intend your work to be produced. Finally, because we live in a time where it's that much easier and simpler to violate strict copyright law or to pirate materials or to distribute them or copy them over the internet, a number of challenges have arisen around the form of copyright law today. For example, very strictly put, on a very technical reading, the copyright law might say that if I have published something on my website, if I've written anything on my website, nobody else is allowed to make a copy of that. However, suppose I use a search engine like Google. Now, when I search for something on Google, what the search engine does is it goes to various sites, looks for what I'm looking for. If it thinks that a website has the sort of content or the sort of material that I'm looking for, it'll take up a little snippet from there, a little piece, a few words, and show them to me on its own search results page. Now, if you think about it in very hyper technical terms, essentially what's happening is that Google is copying content from somebody's website and publishing it again, reproducing it or a part of that work on their own search results page, which would be a violation of copyright law. Now, that obviously really doesn't make too much sense when we compare it against the way we use the internet every day. So there are some challenges surrounding what copyright law should look like because of the internet and how the internet is used nowadays and the increasingly open and sharing sort of environment that we see. And you could read up more about this as well. More materials are on the Education and Technology WordPress website. Well, so that was an overview of the session on Introduction to Copyright Law that we did. Questions, clarifications, doubts, resolutions, additional reading materials, all on the course WordPress website. Thank you.